Hello, good evening, everybody. We are right on time. Let's wait a few minutes to allow others to join, and we will start. So while we're waiting, don't hesitate to use the chat function if you have any question. You can raise hands or simply put a question, and that's I will try to answer either during my presentation or at the end. I will make sure that we have enough time to answer any question you would have. All right, so I'd like to start without further ado. The question today is whether there is a duty to negotiate FRAND licenses in good faith. The answer to that question, in fact, is well known. The answer is yes, of course. Although this answer wasn't that evident, that obvious for many years. But I think it is well settled now under case law that there is a duty to negotiate in good faith, which arise out of the ETSI FRAND undertaking. And I'd like to take you through that and more importantly to explain to you what are the consequences of this duty of acting in good faith in view of reaching a FRAND agreement. I think we can skip this quick presentation. I will tell you more about FrandAvenue in a moment. The very purpose of FrandAvenue is to precisely help market players fulfilling their obligations arising out of the FRAND undertaking, this ETSI system. So why can we say that there is a duty to negotiate FRAND licenses in good faith? Well, that's pretty simple. As I'm sure you know, the FRAND undertaking, which is mostly, if not exclusively, the undertaking which is made under the ETSI IPR policy. The ETSI IPR policy is part of the ETSI rules of procedure. The rules of procedure are a binding set of rules which have been adopted by the ETSI General Assembly and which bind every member of the ETSI. And within those rules of procedure, you can find Annex 6, which is the ETSI intellectual property rights policy. And in that set of rules, you will find in Article 12 the choice of law provision that you would find in any contract, and which stipulates that the policy is governed by the laws of France. So this is why courts, commentators, lawyers have determined that in applying the rules of the ETSI IPR policy, people were bound by a duty to act in good faith. And this duty stems from the French Civil Code. This is Article 1104, which is a well-known disposition under French law, which says that contracts must be negotiated, formed, and performed in good faith. And the code even says that this provision is of public order, which means that the parties to a contract cannot exclude this provision or any duty to negotiate in good faith from their agreement. This also means that the judge will have to apply this principle because that's a mandatory rule. But this duty to act in good faith does not stem only from the law of the contract, the law that governs the at-sea undertaking. It also stems from competition law in France and in other countries. In Europe, the rules have been settled by the European Court of Justice in a famous case of July 2015, Huawei versus ZTE. And in this decision, the court has said that the owner of a standard essential patent is in a dominant position, and that this owner does not abuse its dominant position if it acts in accordance with what certain lawyers see as a very, rigorous step-by-step mechanism. That's mostly in Germany, and other lawyers in France, in the UK, see as an illustration of the behavior that parties acting in good faith must follow in order not to fall within, the prohibition decided by Section 102 of the TFEU, which prohibits the abuse of dominant position. And the Court of Justice has set a number of steps which the parties, the licensor and the licensee, must follow. And this is each of these steps is simply, colored or inspired by the need to act in good faith. And this notion of good faith is even mentioned with respect to what the court says called the alleged infringer or the implementer of the willing licensee, call them as you wish. And this is this notion which we have highlighted in red here. So basically, whether you take this duty to act in good faith from the law of the undertaking, French law, or from competition law, both converge, aim at the same duties or binding obligations on both the licensor and the licensee, which is to act in good faith. Now, let's have a quick look at, how the courts in the world have, what consequences those courts have drawn from this duty. In China, the courts have no difficulty in applying French law to determine to which extent the parties to a FRAND dispute are bound by this duty to act in good faith. And there are a number of examples where the Chinese courts have decided that under French law, the parties had to decide to act in good faith. The same solution in the US, where the FRAND disputes have always been seen as a contract matter. And there are numerous examples of decisions where the courts have applied French law, found that a good faith duty was applying to each of the parties, and drawn consequences. You can find that in famous decisions such as TCL versus Ericsson or Ericsson versus Samsung. And very recently, I was reading Ericsson's complaint against Apple in the recent Ericsson cases, and again, the good faith duty is mentioned in many occasions. In the UK, as we know, the High Court has decided in the Unwind Planet versus Huawei that French law applied, took, and made a decision that applied the principle of acting in good faith, which, by the way, is well known in many other jurisdictions, so that doesn't cause any problem to Chinese, American, or British judges. In France, we have seen the French courts applying the same reasoning in the few FRAND cases in which the Paris courts, which have exclusive jurisdictions on patent matters, have rendered a decision. It's only in Germany where this notion remains to be seen. The German courts very often apply EU competition law, and especially the consequences or the FRAND, as they say, which stem from the decision which I've mentioned a moment ago, and they determine whether the patent holder can seek an injunction to the extent that this patent holder has made an offer in accordance with the various steps described in the ECG decision, and the same would apply to the willing licensee. This notion of willing licensee is very close, in fact, to the notion of good faith implementer or good faith licensor. So I don't think that there's a lot of differences in the approach. It's just that German courts have not yet admitted to take a decision that would clearly apply the law of the agreement, which is the FRAND undertaking. Now, how does that translate? Because those are the principles, but we need to understand what exact consequences this principle has on the parties. And we have to understand that this is not a mere duty of acting nicely. Good faith is more than that, especially in the context of a FRAND dispute, because the FRAND disputes have something very specific as compared to another negotiation between parties who were not bound to negotiate, who were just, talking to each other because one wanted to buy something and the other one wanted to sell something. And that's a nice discussion. They have a duty to act in good faith. For example, they can't play tricks. They can't hold out the other party in a discussion while one of the two other parties using that time to take an advantage. That we have many case law on this. The specificity of the FRAND negotiation is that the parties must reach an agreement. They have no choice, because that's the very purpose of the FRAND undertaking. They have to agree. Otherwise, either the one or the other will be in breach of the law. If the licensor doesn't act in good faith, this entity will be in breach of competition rules and contract law. If the licensee does not act in good faith, the FRAND undertaking can be terminated, and the patent owner can recover the entirety of his rights and seek an injunction. So that's why the specific consequence in FRAND discussions of this duty to act in good faith is that if the parties If either party sees that it is not, the other party is not acting in good faith, this party can ask the court to determine the FRAND terms. The win licensee or the licensor can ask a judge to determine the FRAND terms. And that stems from, the duty of good faith negotiation in this very specific context. Put it differently, the two parties to a good faith negotiation of that kind must put on the table all the information that is necessary for the other party to reach the desired result. And this translates into very specific obligations. Let us see what are the obligations on the licensor and on the licensees. Typically, the licensor must disclose the consistency of its portfolio, its terms, comparable agreements to the extent possible, under confidentiality obligations if necessary, but there are a number of obligations that can be determined from this. And similarly, the licensees must disclose everything that is necessary for the other party to take to reach an agreement on sound basis, such as information about the products, the sales, and potentially the other agreements found for the same products. And again, if the parties disagree, they can always ask a judge to determine the consequences. We are under the contract regime. So how can they achieve this? I need here to share my screen and show you what are the what solutions we have imagined to help the parties understand, well, fulfilling their obligations. This is the tool that we have designed, which is this platform, FrandAvenue, where both licensors and licensees can fulfill their good faith obligations. Let's take the case of a licensor. I will simulate the situation of a patent owner who wants to display its portfolio. We have seen that that's an obligation for the patent owner to show what it is that it is offering to license. So let's take, let's look into the portfolios that are available here. I'll take just an example, a mock portfolio, because I don't want to, to let you think that I will be displaying confidential information to somebody else. For example, this one. This is a 4G, 5G portfolio where this hypothetical licensor has displayed a number of patents. That's a very small portfolio here. That's just for the sake of the demonstration. As you can see, you have here a few patents. You can see the patents very easily, so the other party, the potential licensees, can very easily. I'm sorry if it is very slow tonight. That's because I'm presenting on Livestorm, and that's slowing it down. But if you go and have a look by yourselves, you will see that it's pretty fast. So here you will have the patent. You could easily find it. That's an Ericsson patent or assigned to another company, and you would easily find it. You could see, the associated portfolios. For example, you could see the Ericsson 5G patent, and you could easily determine. Again, I apologize for the time it's taking, because it's much faster normally. You would see all the 5G Ericsson patents. Sorry, I will. Clearly, it's not working when I'm presenting on Livestorm. But here, back on this mock portfolio, I can see for example, the content. I can see the licensing program. And this licensor can determine for a given portfolio what would be, for example, the negotiation timeline. One of the main difficulties that licensors encounter these days are the situations where they are held out, where they have infinite negotiations with reluctant licensees. So they don't want to waste time from the outset. So what they do, what we offer licenses to do, is simply to determine the timeline. That's an example. You can adjust it as you wish. And if you decide that you don't want to spend more than, in this example, 9 weeks for negotiating a non-disclosure agreement, and 10 weeks on due diligence, and so on, and that's your conditions, which you may adjust. You may even say, well, okay, in the event that that we would not reach an agreement on any of these steps here, I'm prepared to go, for example, on this dispute resolution mode. In these locations, with these institutions, I can disclose or hide my choices. I'm not bound, I'm not obliged to display them, but at least I can show what I'm prepared to do. And if the other party doesn't want neither Paris, New York, London, Munich, wherever, then that would immediately show that this licensee is not a willing licensee, and the licensor will have his hands free to act back into the wild and say, well, I'm not talking to someone who is genuinely, in good faith, willing to achieve an agreement. So I'm asking the judge to terminate this FRAND undertaking and to let me enjoin and find an injunction. Similarly, the licensee can do the very same. So here I was showing you an example where you have a licensee, but I could take a licensor, I'm sorry, but I could take a potential licensee doing the very same. And again, I'm very sorry about this delay, but I think you have understood the idea. If I look in our members and I look for an implementer, I will find that an implementer can very well display, for example, an implementer can display the its licensing in conditions. In this example, the implementer presents itself, that's a very limited presentation that we put here, say, okay, fine, I'm willing to enter into patent license agreement with relevant licensors. I have set my preferred negotiation timeline and dispute resolution process to show my good faith. I'm saying, okay, fine, I'm willing to enter into discussions, but I'm not willing to enter into abusively quick discussions or abnormally long negotiation. I want a reasonable timeline, and in the event where we would not reach an agreement, I'm prepared to go ask a given judge, mediator, arbitrator to adjudicate this matter. I'm even going further in my duty to disclose my needs by explaining what are my implementation needs. In this example, for example, I'm not interested in smartphones. I'm not a smartphone manufacturer. And I don't want to have to take a license for smartphones because I'm not supplying smartphones. I'm supplying other stuff, IoT, for example. In my negotiation terms, if I take, I don't know, this one, healthcare, I have, well, I'm prepared to have a non-disclosure agreement for this amount of time, followed by a due diligence period of whatever weeks, 4 weeks here. Negotiation of the key terms would take a maximum of 6 weeks, and 8 weeks for closing. Same for the dispute resolution process. So, and keep going on, and I can see that I'm very open. What it gives me is very simple. I have evidence that I'm playing in good faith, that I'm playing, a very reasonable game where I explain what are the minimum conditions which I am offering to enter into discussions. And I'm even prepared to ask a judge to determine the FRAND terms in the event that we would not reach it. So I can't be blamed by playing the game of catch me if you can, that so many unwilling licensees are playing. That game exposes the players to the licensor seeking injunction, because when the potential licensee doesn't play fairly in good faith, that's the consequence. So if a genuinely good faith actor, implementer, wants to protect himself from abusive, hold-up situation, that's what he should do. So that's a two-way street, FrandAvenue. For licensors, for implementers, they both can find, ways, tools of demonstrating their willingness to act in good faith, which is the underlying principle in the FRAND game. So I think if you wish to visit the platform, that's very easy, and you will easily play with these features. You might have questions. Or I can add a few comments if you wish. The first comment I'd like to make is that the duty to negotiate in good faith is not necessarily the same in all industries. A judge will not will not assess the extent to which a large market player who has been through a countless number of FRAND negotiations, this player has a heavy duty to negotiate in good faith. I mean, the obligations binding upon this player will most certainly be assessed in a more severe, strict manner than the obligations which bind a newcomer, a new entrant into this market. A new IoT manufacturer who is completely new, has no experience in these negotiations, should not have the same, obligation. The obligations should be construed slightly differently. The same goes for licensors and licensees. An experienced licensor does not have the same duties than just a new one. Finally, I'd like to say that good faith doesn't mean that the offer or the counter-offer must be truly FRAND. By definition, when the parties cannot reach an agreement, one of them at least, and maybe the two of them, might be offering or counter-offering non-FRAND conditions. That's very normal. In the unwell-planned decision, there is a passage of the decision on this where Justice Beers said that. That's very normal, and that's exactly why they couldn't reach an agreement and why the judge is competent to decide here. The fact that the parties do not reach an agreement does not necessarily mean that they have not acted in good faith. They, in good faith, offered to the other party the possibility to make a decision. They failed, but that's how it is. And at the end of the day, a judge will adjudicate this. And it's only in the event that the parties would not respect the terms decided by the court that, of course, then other remedies would become available. I think I've spoken too long. Well, if you have other questions, I'd be delighted to answer. Apparently, there is no question, so we are straight, on time, pünktlich, and I wish you a very nice evening. I should just add that this webinar was recorded and the video will be available on our website in the coming days. Thank you very much and have a nice evening. Goodbye.